Pure unfiltered privilege meeting its absolute destruction. That is the only way to describe what happened the morning Madison Whitmore sat down in the defendant's chair of a television courtroom and decided she was going to teach a judge about how the world works. She was 19 years old, dressed in an outfit that cost more than most people's monthly rent, and she carried the specific brand of smug superiority that develops in people who have spent their entire lives watching consequences bounce off them like rain off a waxed car. Her manicured nails drummed against the armrest with practiced impatience. The condescending curve of her lips communicated to everyone in the room that she believed this was a minor inconvenience her father's name would dissolve before lunch. She had no idea she was sitting across from a woman who had spent 25 years making exactly this kind of person answer for themselves before Madison was old enough to drive. And she had no idea that the words already forming on her lips were about to trigger the most comprehensive judicial dismantling she or anyone watching would ever witness. "My dad is the governor. You cannot do this to me." The silence that settled over that courtroom after those 7 words was not ordinary silence. It was the silence of a room that understood all at once that something significant was about to happen. But before that moment, you need to understand who Madison Whitmore actually was, because this was not an isolated incident. This was the product of 19 years of accumulated impunity. Madison was the only daughter of Governor Robert Whitmore, a man who had spent 2 decades climbing to the highest office in the state. From the moment she was born, Madison had lived inside a bubble of access and luxury so complete that the concept of accountability had become genuinely theoretical to her. Private schools where tuition exceeded the cost of college, designer clothing worn once and discarded, a fleet of expensive vehicles, and the institutional understanding confirmed repeatedly throughout her adolescence that the rules were a framework designed for other people. Her first car arrived on her 16th birthday, a $75,000 BMW. She totaled it within 3 months, rear-ending another vehicle while texting. The other driver was prepared to press charges. Within 24 hours, the governor's chief of staff had produced a settlement agreement and a non-disclosure agreement, and the problem had disappeared entirely. Madison absorbed a lesson from that incident. Not the lesson her parents perhaps intended. She learned that her father's position meant she could escape anything as long as the family had sufficient money and influence to make victims accept a check and a contract and stay quiet. Over the next 3 years, she would be involved in 6 more accidents. Each one followed the same pattern. Reckless behavior, intervention from the governor's office, a settlement that barely covered the victim's losses, a non-disclosure agreement, and silence. 6 times. Not once did Madison Whitmore stand in a courtroom, face a judge, or answer to anyone for what she had done. The incident that finally changed, that arrived on a sunny Tuesday afternoon in March, and proved to be the one mistake her father's resources could not make disappear before enough people had seen it. Madison was driving her 3rd vehicle, an $85,000 Mercedes she had received as a college enrollment gift, despite barely attending the expensive private university that gift was meant to celebrate. She was moving through a shopping center parking lot at nearly 40 miles per hour in a zone clearly marked for 15, her phone in one hand and the other barely touching the wheel. She never saw the parked Honda Civic before she hit it with enough force to spin the smaller car sideways into a light pole, crumpling what had been a maintained and reliable vehicle into twisted metal and broken glass. Madison sat in her SUV for perhaps 10 seconds. She checked her reflection in the mirror to confirm she was uninjured. Then security cameras recorded, in high definition, what she did next. She laughed. She said something to her passenger that made them both laugh, and then she drove away. No information left. No acknowledgement of the destruction she had caused. No check on whether anyone had been hurt. The owner of the destroyed Honda Civic was Sarah Martinez, a 34-year-old single mother who was inside the grocery store when Madison's reckless driving reduced her vehicle to wreckage. Sarah worked as an emergency room nurse at the county hospital, pulling double shifts and additional hours at a free clinic to provide for her 6-year-old daughter and 8-year-old son. She had saved money for 3 years to buy that car, giving up every luxury and working holidays and weekends because reliable transportation was the difference between holding her life together and watching it unravel. When she came out of that grocery store and saw what remained of her vehicle, her first emotion was not anger, it was terror. Without the car, she could not reach work. Without work, she could not pay rent or feed her children. That single moment of Madison's carelessness had placed everything Sarah had spent years building at genuine risk of collapse. Security footage captured Madison's license plate clearly, and within hours the vehicle had been traced to the governor's mansion. But before the police could complete their report, before Sarah had even been contacted by investigators, an attorney from one of the state's most expensive firms appeared at her apartment door. He came with a briefcase and an offer presented as generosity. The governor's office was prepared to pay her $5,000 in exchange for a settlement agreement and a non-disclosure contract that would prevent her from ever speaking publicly about the accident or Madison's involvement. $5,000 for a car that would cost at minimum $8,000 to replace, and all she had to do was agree to silence. The lawyer characterized this as a gift. He made clear that fighting the governor's family would be expensive and futile, and that she should be grateful for their willingness to help her at all. When Sarah asked for time to consider, his tone changed immediately. The offer was only available for 24 hours. Refusing would be a serious mistake. She should think carefully about what was best for her children before making any hasty decisions. That veiled threat changed everything. Sarah had grown up without money. She had worked her way through nursing school while raising 2 children on her own. She had faced down aggressive patients and dangerous situations in an emergency room. She was not going to be intimidated by an expensive attorney protecting a girl who had destroyed her property and driven away laughing. Instead of signing, she began researching. What she found made her angry in a way that clarified rather than paralyzed her. Local news stories about hit-and-run accidents involving luxury vehicles that had been resolved without charges. Social media posts from people describing pressure from lawyers representing powerful families to sign non-disclosure agreements after accidents. A pattern that suggested Madison Whitmore had been operating this system for years. Sarah reached out privately to 3 previous victims. One had been forced off a highway by Madison and spent months in physical therapy. Another had his truck destroyed when Madison ran a red light and hit him directly. A third was an elderly couple whose car Madison had struck in a parking garage before accelerating away. Every single one of them had been approached by the same law firm. Every single one had been offered settlements that barely covered their losses. Every single one had signed the non-disclosure agreement and accepted the money because they could not afford to fight a governor's office with unlimited resources and institutional power. Sarah refused to sign. Within a week, anonymous complaints appeared at her hospital alleging patient rudeness and medication errors, all without any basis in reality. She had worked there for 8 years with a spotless record. Suddenly, there were investigation meetings, written warnings appearing in her file, and whispers about possible suspension or termination. A dark sedan appeared outside her apartment building repeatedly. Her children came home from school and told her a stranger had been asking their teachers questions about the family. When her supervisor called her into a private meeting and suggested with visible discomfort that it might be in everyone's best interest if she reconsidered her position on this legal matter, the meaning was unmistakable. The governor's office had applied pressure. Sarah's job was in jeopardy because she refused to let Madison escape accountability. Her children began asking why the mean girl's daddy was trying to hurt them. Her 6-year-old had nightmares. Her 8-year-old was getting into fights at school because other children were teasing him about his mother being in trouble with the governor. The turn came when Sarah found an online support group for hit-and-run victims and shared her story. Her post was seen by a civil rights attorney named Marcus Webb, who had built his career fighting cases against powerful families who believed they operated above the law. Marcus offered to represent her at no cost. Not for financial reasons, but because the pattern of behavior he saw in Madison's history and the governor's systematic cover-up operation genuinely disgusted him. He filed suit for the full replacement cost of Sarah's vehicle, her lost wages, and compensation for the harassment she had endured. He sent copies of all evidence, including the security footage and the threatening communications from the governor's lawyers, to news organizations and investigative journalists who had been looking for precisely this kind of story. Within 48 hours of the footage being released, the video of Madison laughing at the damage before driving away had been shared thousands of times. When producers from Judge Judy's program contacted Marcus about bringing the case to national television, he understood immediately that this was the exposure that would make it impossible for the governor's office to continue its campaign. Judge Judy's research team investigated for a full week before the taping and uncovered a picture considerably worse than the public had seen. All 7 previous accidents confirmed copies of all settlement agreements obtained, financial records revealing that some of the settlement money had come from the governor's campaign funds, which was illegal misuse of political contributions. Text messages between Madison and friends in which she openly mocked her victims and described her immunity from consequences as a consequence of her father's position. Madison arrived for the taping, treating it like an amusing social occasion. She posted videos from her hotel room trying on designer outfits before settling on a Chanel suit. Her friends commented that she was going to destroy this television judge who did not understand how the real world worked. Her attorney, Thomas Berkshire, who charged $800 per hour and had managed the successful cover-up of all 7 previous incidents, had attempted 4 separate times to have the case dismissed before it reached the courtroom. Every motion was denied. He had even attempted to pressure the show's producers directly. Judge Judy had made it clear that Madison Whitmore would face the same standard as every other defendant who walked through her doors. Madison arrived with an entourage: her attorney, her father's press secretary there for damage control, and 2 socialite friends who treated the proceeding like a fashion event. She was wearing designer sunglasses indoors and carrying a bag worth more than Sarah's destroyed car. She walked past Sarah in the waiting room without acknowledgement, laughing loudly with her companions about plans to go shopping afterward. She was audible telling them this whole thing was ridiculous, that Sarah should have taken the money, and that television court shows were not real courts and the ruling could easily be overturned. Judge Judy opened the proceedings with the signature directness that had made her a fixture for 25 years. Miss Martinez, you are suing Miss Whitmore for damages from a hit and run that destroyed your vehicle. Tell me what happened. Sarah's testimony was quiet and entirely without performance. She described coming out of the grocery store to find her only means of transportation destroyed. She explained that she had saved for 3 years to buy that Honda Civic. She detailed the impact on her ability to work and care for her children. When she described how her children were having nightmares and asking why the mean girl's daddy was trying to hurt them, her voice broke and tears followed. The courtroom sat in complete silence. Then Madison approached the podium and the entire atmosphere changed. She walked to it with runway confidence, her heels striking the floor with deliberate authority. She opened with what was clearly a rehearsed apology, the kind that sounds like something written by someone who has never actually felt sorry about anything. Your Honor, I want to say I am sorry that Miss Martinez's car was damaged. She immediately pivoted to explaining that the parking spot had been confusingly positioned, that the lighting in that section was poor, and that she had not realized the damage was as significant as it turned out to be. Judge Judy's first interruption arrived fast and precise. Miss Whitmore, I have seen the security footage. You were driving 40 miles per hour in a 15-mile-per-hour zone. You were looking at your phone. You hit a parked car with sufficient force to send it into a light pole. You then laughed, made a comment to your passenger, and left without providing any information. Would you like to revise your description of this as an unfortunate accident? The color shifted in Madison's face, but her attorney immediately raised objections about the admissibility of the footage. Judge Judy turned to him with an expression that has a well-documented history of ending arguments. Counselor, your client is 19 years old and entirely capable of speaking for herself. Sit down. Do not speak unless I address you directly. Madison was visibly off balance now, the confidence cracking at the edges, as she realized the proceeding was not following the script her legal team had prepared. Judge Judy leaned forward with the controlled expression that regular viewers recognized as the moment before something very bad happened to someone who deserved it. Miss Whitmore, is this your first car accident? Madison hesitated, clearly trying to calculate what information the judge already possessed, and answered carefully that she had been involved in a few minor incidents. Nothing serious. Judge Judy opened the thick folder that had been sitting on her bench since the proceedings began, the same folder that had visibly unsettled Madison's attorney from the moment he spotted it. A few minor incidents. Let us define that. How many accidents have you been involved in over the past 3 years? Madison offered that she could not remember precisely. Maybe 2 or 3. Nothing worth discussing at length. 7, Judge Judy said. 7 accidents in 3 years. 7 victims whose property you damaged. 7 settlement agreements funded by your father's office to ensure those victims accepted payment and stayed silent. I have every agreement in this folder. 6 prior victims. Total payments of $47,000. And a particularly interesting detail. Some of that money came from your father's campaign funds, which constitutes illegal misuse of political contributions. The courtroom erupted. Madison's face moved through pale to bright red as the inventory continued. Then Judge Judy asked the question that produced the answer, revealing everything about how Madison Whitmore understood the world she lived in. Miss Whitmore, why did you leave the scene of this accident? Madison's response was immediate and entirely unguarded. I did not think it was that bad. It was just an old Honda. The collective reaction that moved through the gallery at those 6 words was something no amount of preparation could have anticipated and no amount of money could have contained.